Okay, good morning. Welcome to the Traffic Safety Hot Dish for TZD November 2024. We really appreciate that you're here today. You're going to hear from a couple of really good speakers from other areas of the country. So we welcome you here. Jackson, there we go. My name's Carrie Meyer. I'll be moderating today. Hopefully, most of you know me by now. I'm the Minnesota Judicial Outreach Liaison. I have been since 2021. I'm also the Chief Judge in the 4th Judicial District, which is Hennepin County, for those of you in Minnesota. You'll know that. I'm really excited to help moderate today. The Judicial Outreach Liaison is a program that's really run through NHTSA, who is one of our sponsors here today. And you're going to see people from all levels of the Judicial Outreach Liaison program. And so I'll introduce the two speakers who are at different levels than me in a moment. But again, I'm a state Judicial Outreach Liaison, and I am the Minnesota JOL. We really want to thank our sponsors today. As I said, NHTSA is one of them, the National Highway Traffic Safety Administration, as well as our Minnesota partners, Department of Health, the Department of Public Safety, and the Department of Transportation. So we know they run the ACTS team, they co-chair the ACTS team, and are always so supportive of Towards Zero Deaths. For your information, as I'm sure you heard as you joined, this webinar is being recorded. It will be posted for those who joined us today. You are muted as attendees, and we'll explain to you how you can get questions submitted here in a moment. If you want to file for professional development hours, the form can be found on the TZD safety webpage, the Hotdish webpage, and you can see the URL is right there. I believe there is going to be an email that goes out later. It's going to have the URL code and for feedback, and I expect it will also have this link as well so that you can put in for your professional development hours. Okay. If you want to reach us, this is how, right? Because you're muted and you will stay muted throughout the seminar or the webinar. So you can share with everyone by using the chat function, including if you need any technical assistance. Like if you think I'm muted because my lips are moving, you can't hear me. Anyway, you would put that in the chat. But if you want to ask us a question, please put that in the Q&A. And this bar that you're looking at, this strip or graphic is actually the buttons that should be at the bottom of your screen if you are on a computer. You'll find your toolbar. Just look. If it's not at the bottom, it'll be somewhere along the edge of your computer. You should have a Q&A and a chat function to be able to reach us with your questions. Again, put the questions in the Q&A. I'll be monitoring those and ask them at the end. All right, we have two speakers today. As I said, we are bringing you all levels of the Judicial Outreach Liaison program from NHTSA. As I said, I'm a state Judicial Outreach Liaison. Judge Anchando is a regional Judicial Outreach Liaison. He is from the 6th NHTSA region. He is the long-term presiding judge of the 1st DWI court in El Paso, Texas, and he sits on the El Paso County Criminal Court, and one of his jobs is to preside over that DWI court. They just weeks ago celebrated their 20th anniversary, quite a milestone. Their court also is an academy court where other courts go to learn about how to do DWI court well. In fact, it was the model for Hennepin County when we started ours just 2 years after El Paso started theirs. We're really honored and privileged to have Judge Anchando here to share some of the lessons from his DWI court with us. He's joined today by Judge Kate Huffman, who is the next highest level, the highest level of the JOL program, being the National Judicial Fellow. She kind of makes sure that all of us have information that we need, that it's posted for us, that we can bring you information if you need it, as well as gets us all together a couple of times a year. And her day job, like all of us, she does have a day job. She's on the Court of Appeals in Ohio's Second Judicial District. And she's chambered in Dayton, Ohio, for those of you familiar with Ohio and interested in that geography. So they're together. They're not in Texas or Ohio. They're actually at the National Judicial College this week doing presentations there. So they're in a room together in Reno, Nevada. And we really appreciate your time to join us today, Judges Anchondo and Huffman. I understand Judge Anchondo will have the first part of the presentation, and then we'll come back at the end with some Q&As. Thank you for joining us.
Carrie, thank you so much for those kind introductions. And it gives me great pleasure to be with you all, and even more of a privilege to be co-presenting with Judge Huffman on some perspectives on what the judiciary does in these cases on impaired driving that you all are familiar with in your community nationally, and you hear a lot of news about these impaired drivers. And we wanted to bring you some perspective on that. I'll be presenting first, and then I'll turn the throne over to our Judge Huffman. But I wanted to all thank you not only for what you do, but your collaboration with us as judges, because we have a very important role in how we deal with these impaired drivers. So what we're going to do here today is learn the following. And let me see if I'm going to do all this correctly today. Here we go. Some learning objectives for you all so that we have maybe kind of how we're going to be presenting to you. So we're going to be determining the impact of dangerous driving, including impaired driving, speeding, seatbelt usage, distracted driving, and how it affects our communities. Understand the function of what we do as judicial officers and court staff and others in promoting this public safety on our roads to make them safer, that when we have these individuals, we return them back onto our roads, and that they're at least more structured and actually being safe. Explain the important role played by the criminal justice stakeholders, such as you all. You could be those stakeholders in informing judicial officers regarding critical facts, any kind of plea negotiations factor that goes into that. And then we ultimately have the role of sentencing considerations, impaired driving in these cases. Oops, going too fast. So these are the kind of things that we do as drivers. We're here at Reno, and I was kind of told yesterday by Dr. Harmon that these are just some of the things that we do. They actually told us that we do about 1,700 things when we're actually driving our car. We have to buckle up. We don't want to be drinking and driving. We certainly want to stay focused. We certainly want to respect our intersections, stopping at red lights, and watch out for pedestrians. So these are just some of the things that we share with you, because these are one of the many things that we do with drivers. Let's find out what we look like as a U.S. population. You know, where we live in the urban areas, we make up about 81% of the population. And in the rural areas, we make about 19%. But where lives are lost on our U.S. roads, if we look at the urban and rural, you'll find out that even in rural areas, we lose a lot of people in traffic fatalities, almost 45% that we lose. And in this particular graph, we're presenting to you statistical information that in 22, there was 3 behavioral factors that contributed to fatal crashes, and that was alcohol impaired driving, as you can see on the green portion, speeding and seatbelt non-use. All of these, and amongst others, were leading contributors in fatal traffic crashes. So what are we looking at, folks? Well, we as judges are learning that these factors that you see on the screen, speeding can be aggressive behavior, serious behavior contributing to our fatal crashes. Distracted driving can be many things. Cell phone use, we're eating, we're using, we're fumbling with the phone, we're doing other things in the car, not wearing our seatbelt use just in case there's a collision, it contributes to the fatality, and of course, impaired driving.
Judge Anchondo, I'm sorry to disturb you, but can you change the display setting just so that the screen's bigger for everyone?
Okay.
Thank you.
Thank you.
How do we do that?
Trying to do
Up
that.
at the top, there you go.
Okay.
Is this what you wanted us to show?
Yeah, push that button. Let's see what happens. It worked last time.
Which button?
That one, the first on the drop down.
How's that?
No, we're still seeing presenter view.
Do we do a duplicate
Let's
slideshow?
try this one.
Oh, now we don't see your slides at all. I'm so sorry to interrupt your presentation. It's
Oh,
just
no,
we're
we
seeing
want
your,
to make sure we're doing this correctly. We understand. But I'm just not,
What are you seeing now?
perfect.
Oh,
over there?
I don't know what we did, but thank you.
Okay, great. All right. So continuation of what we're talking about here is those who drive under the influence of alcohol are more likely to engage in other high-risk behaviors such as speeding and not wearing seat belts and many other things. So we know as judicial officers, because we've learned this through many of our partners, that these are contributing factors that causing our roads not to be safe for the people that drive.
Let's,
So now I'm not moving forward, Carrie.
let's,
What do we do?
I don't know.
I don't know what we're doing, but we're doing something.
There we go.
All right, so let's look at some figures, folks, so you'll know what we deal with while we're on the bench and we get these cases. But nationally, in 2022, there were 13,000 alcohol-related traffic fatalities in the US. That's a lot of people. That represents almost a third of all traffic deaths. 32 people in the US die every day in impaired driving crashes. That's one person every 45 minutes. Astonishing. In 2019, there were over 1 million people arrested for DUI in one way or another. And there were over 121 million impaired driving episodes. So as you can see nationwide, this is a serious epidemic that's going on in our nation. And impaired drivers get behind the wheel and drive between 300 in our urban areas to 1,200 times in rural areas before the first arrest. According to Professor Latessa, that can even be 80 to 200 times before somebody gets an arrest. So, usually when we hear someone saying, Judge, what is the big deal? It's my first DWI. Well, it's really the first time that you were arrested, really not your first time. We already know that this has happened before. And we have to also look at these things. A study of repeat offenders indicates to us that the person in front of us, before us, 45% of the individuals have a lifetime major mental health disorder. So we're just not only having a choice of drinking and driving, but they also are suffering from some mental health disorder. And we also have to find out how we're going to treat that and get the information we need to be able to treat it. We're talking about mental health issues. These are linked to the following. A lot of people are driving with depression, bipolar disorder, conduct disorder of some sort, anxiety for many reasons, antisocial personalities, PTSD. So when we have these individuals, we always have to make sure that when we have them, are we getting information to start looking at this? What is the root problem? What is causing this drinking and driving or drug driving these folks? Because they may be under medication as well. So these are many things that we have to look at. Chronic heavy recreational cannabis use. Now we're dealing with drug driving in our country. We have a lot of states now legalizing marijuana. And we're learning even here at the college of what chronic use does with these folks. It causes psychosis. It causes a lot of problems that we have to be dealing with. In 2022, daily or near daily marijuana use exceeded daily alcohol use. So as you can see, more people are smoking. They're smoking that weed and not drinking as much. But when you contribute both of us, that becomes a very serious problem in our country. It's a bad combination. Alcohol use alone consistently associated with elevated motor vehicle condition risks. We already know that. That is contributing. Alcohol still remains one of our leading causes of fatalities and serious bodily injuries in our country. But if you now go and start having cannabis adding to that equation, boy, then we're really creating an elevation of motor vehicle collision risks in our country. So we have to be wary of that. As judges, we have to learn from that. We have to make sure that we're some way making sure that we're preventing from that conduct continuing. And then of course, we're struggling with the drug data. What happens most of the time on roadside when our officers stop these individuals, they get pretty good about alcohol. If they determine that these folks have enough to make the arrest for alcohol, we usually stop there. And we're trying to send the message that we need more. We shouldn't stop there, that we should find out if these individuals actually are ingesting other substances into their body so that we understand what's going on. Because we're also understanding that it's just not alcohol alone. Data is being reported inconsistently. We don't have stakeholders talking to each other the way they need to. And we also understand that many of these drivers who cause crashes, who are arrested, don't just have that alcohol, but they have one or more drugs in their system, making it difficult to know which substance had the greater effect. And not even that, but we certainly don't even know sometimes, and this is what causes some of our problems, especially for officers and prosecutors, is what drug actually caused any impairment. Was it the alcohol? Was it the drug? We don't know. And this is why we need to gather more information and not stop just because it's alcohol. We should go a little bit further. What we do know is the following. 2022, this report indicates that we analyzed toxicology data from our 4 labs, including drivers arrested for drug driving and fatally injured drivers. Between 71 and 99% of those drivers tested positive for one or more potentially impairing drugs. That's quite a bit. And approximately 50% of those drivers had more than one drug category present on any toxicology screen. So as you can see, what we're dealing with in this particular area is a significant problem of people just ingesting a lot of substances in their system. Drug driving offenders are 5 times more likely to reoffend as compared to just your alcohol drivers. That's an astonishing figure. We know that these people are probably smoking a lot and they're actually driving. And, we have to recognize that, especially in the states that have legalization of marijuana. Drug driving where a scheduled prescription was also the impairing substance, reoffend much less frequently, about 70%, compared to those who consume illicit drugs, which is a higher percentage. So we know that folks out there are just ingesting a lot of things. And as a judicial officer, it's always very difficult for us to find out what they really are suffering from until we get information that's going to help us make those determinations. 22 facts on speeding. Let's go back to speeding. I think a lot of people don't pay a lot of attention to this particular statistical information. COVID did a lot to this country, and it just caused a lot of problems. And the figures are coming out that 28% that's of fatal crashes, 12% of it injury crashes, 8% of property damage only crashes were causing by speed-related incidences. That means that 12,150 fatalities in speeding-related crashes represents almost 1/3 of total traffic fatalities in this particular year. 35% of male drivers and 21% of drivers in the 15 to 20-year-old age group. These are the people that are just getting their license, really becoming a voting age, drinking age, are causing a lot of our problems on our streets because of the speeding. More than half, 52% of speeding drivers and fatal crashes were unrestrained. So they weren't using seat belts, which caused probably more of the demise and more of the injuries. And among speeding drivers involved in fatal traffic crashes, again, almost 1/3 did not have a valid driver's license. So we're seeing a lot of people just not going and taking the test and learning about proper driving skills. So speeding drivers involved, another graph is the following, not a graph, but the information indicates that people with 0.08 or greater were involved in 38% of the incidences. Now that's our legal intoxication rate in most states. But even higher at 0.15, which is almost double, 20%, 26% were of that BAC amount at the time of their incidences. So Folks, all I can say, this information is very important for us. And we certainly have to be looking at driving history of people that come before us. Distracted driving, no brainer. We do this, guilty of it, okay? We just have to be aware that even distracted driving is causing a lot of our fatalities because we're doing a lot of things in our cars when we're driving. We're looking at things and sometimes we're distracted. I mean, I've lost family members. I've lost close friends to distracted drivers. I'm pretty sure some of you have. We have to be cognizant, and that's why we have to be focused on what we're doing and keeping an eye on the road. But this is causing a lot of our problems in this country. Let's see, this is a video. It's about 20 seconds and it's low volume. So we hope that you all can hear it. Okay.
About the suspected drunk driver who drove the wrong way on Interstate 80, killing 4 members of one family. The CHP says 32-year-old Michael Kelly was driving the wrong way near Democrat Grant earlier this month and hit a Sacramento family's car. The mother and father and 2 of their children were killed. Investigators now say Kelly was on probation for a previous DUI. Authorities say a 4-year-old was the only surviving family member and will now be adopted by his aunt and uncle.
Now, you know, those news casts, they're just prevalent. We had a family in El Paso 2 days ago. A person retired as a teacher, the fiance, and they were all going to go to Florida, and a repeat offender on our streets, as you heard of this broadcast, repeat offenders. And you know, folks, those are the folks that we're dealing with, those repeat offenders, and they're out there. But this is what happens, and it's a tragedy not only to the driver's family, to the persons who are no longer with us. And so this is the reason why we do this and we present to you all, because this is a serious problem in our country. And these are the stories that we bring to you because they do affect and destroy families. But you know what? This is what we do. We have to seize the opportunity. See, every time an individual is before us or Judge Huffman and our judges, Judge Meyer, we have to always look that this is a perfect opportunity. When these people come before us, this is an opportunity to start asking the questions, learning about an individual's life, identifying their clinical needs. Are we doing screening? Are we doing assessing? What is truly causing the problem? What is going to change this behavior? So we're going to have to start really digging deep into this. And this is an opportunity to be doing this. And we're learning this because of the training and the research that's coming out, the best evidence practices of how to start changing these people's lives. And we're also understanding that a lot of these cases that come before the courts actually don't go to trial. They don't go to a trial by jury. They end up pleading. But if they do plea, and this is an astonishing figure here, 90 to 95% of all state and federal criminal cases are resolved by plea bargain. If it is, then we as sentencing judges have to start looking at a lot of things when we're going to be sentencing folks, especially if they're going to be pleading. For a lot of us in the justice system, we have heavy caseloads. We know that. We're burdened. These plea agreements, what is the basis? What are the factors leading up to the plea? What are the factors that you're presenting to the court regarding this plea? What are the conditions that are being presented to the court? Are those really going to make an impact in the individual's life? Is it going to make our community safe? Are we dealing with incomplete information? And sometimes we do. We're not getting the total information on the individual, their history, mental status, character, things of that nature. Lack of system coordination. I know we deal with that, especially in the rural areas. A lot of agencies don't speak to one another. So we're not getting the right idea. So we have to improve on these things, and we're spending the message out. Reporting systems and procedures. How are we doing it? Are we doing it effectively? And we all know that there's lack of financial resource. We know that. So sometimes we as judges have to be thinking outside the box and getting people that can help us without putting a financial burden on their agencies. And then we don't have sometimes the inadequate, or we don't have the personnel to be supervising these individuals while they're on bond, make sure that they don't pick up any new offenses. Or we're not getting the information that they're not abiding by those conditions. At post-sentence, that means that when we're sentencing these individuals, Are we adequately supervising to make sure that everything that we discovered at sentencing is being done by these individuals? Are they going to their treatments? Are they reporting? Are they engaging in treatment? And if they're not, then we need to know. Are they violating their ignition interlock or any alcohol monitoring unit? And we need to address that. So many challenges that we have when we do this. Plea agreements, for some of us in our jurisdictions, we ask ourselves, am I required to accept this plea agreement? Do I have to? Do I have to follow this recommendation? Maybe I don't like what's being presented to me. Do I have that discretion to have these folks relook at what they're presenting to me? Because I'm not satisfied that this is going to be an impact and it's going to make our community safer. And what more does the judge need to know before considering the recommendation? Am I getting all the information I need? Sometimes that's where you all come in what you do in your area of expertise in your careers. And what and who influences court decisions in traffic cases? Many factors, many factors. I mean, I have just exposed to you some of the things that we need to deal with, but there are many things that we need to do as judges to be able to make our decisions. So there are many things that we need to look at. Here's just a prime example of something that comes to us all the time. Prosecutor announces a plea agreement where the defendant will plead as charged to a DUI. Defendant has 2 prior arrests that resulted in reckless driving. So they dropped those. Those weren't convictions for DUI. They were convictions for reckless driving. Prosecutors recommends a fine. Unsupervised probation. No treatment required since technically this is the defendant's first DUI conviction. That's the way they're treating it. And he's attending a six-week alcohol education program. I have to look at that, folks. I mean, I have to make sure, is this something I really want to accept that's being presented to me? Do I ignore that there's 2 DUI arrests? Do I ignore that they resulted in reckless driving convictions? Do I think a 6-week alcohol education program is enough for this individual who now has 3 DUIs? So a lot of information here needs to be looked at. I have to make these decisions, and I know it's hard for us as judges to make these decisions. So what does the judge need? What do I don't know sometimes? Well, folks, sometimes I don't get much information. And this is why sometimes we lack those resources, the system coordinations, agencies talking to each other, because at this point, this is what makes it different. So this is where we make a difference from the judiciary. These are the perspectives that we look at in making a difference in our community. At this time, folks, I'm going to turn it over to my co-presenter, Judge Huffman. Judge.
Thank you. So I'm going to go back a slide just for a second, because as Judge Anchondo has mentioned very thoroughly, that impaired driving is a very complex problem, in that the individuals may engage in a variety of risky behaviors, including speeding, not wearing seatbelts, distracted driving, and combining those with impaired driving makes our streets unsafe. And as you saw in that short video, hopefully you could hear it, a family, 4 members of a family were killed by a repeat impaired driver. 1 4-year-old child survived, thank goodness, but has lost the rest of her family. We also know from the data that about 2/3 of first-time arrested impaired drivers self-correct. That means, for whatever reason, to them individually, they do not get a new DUI offense. It may be because they've been, for lack of a better term, shamed by the experience, whether it was going to jail for the night, their family, friends, co-workers, employers learning of their arrest. It may be because of the cost of the impaired driving offense, cost in terms of dollars, whether it's a fine, a cost for an attorney, posting bail, losing some time at work, but also that intangible social cost of the potential for a conviction. So it is and then we couple that with the prevalence of mental health concerns among impaired drivers, and the very complex concern today about drug impaired driving. because even though Judge Anchondo gave you a great deal of data about drug impaired driving, we don't yet have a really good grasp on the number of people who drive under the influence of drugs. That is certainly data that the entire highway safety system is attempting to collect. But as Judge Anchondo also said, there are often reasons why we don't have that information. Judge Anchondo also mentioned that because the vast majority, almost 95% of all cases, including DUI cases, end with a plea, that means the judge hasn't heard any of the facts about the case. They haven't heard any testimony. And so really what they know about the individual is often simply that they're entering a plea to a charge, but they don't know the important case-specific facts and details that help shape a sentence. In addition, Judge Anchondo also mentioned that we often have a lack of system coordination, and that system coordination often can mean that the judge does not have accurate or up-to-date information about whether it's impaired driving offenses or other dangerous driving behaviors that help influence the judge's sentence or bond. So just like in your professions, you all utilize evidence-based practices to shape whether it's your decisions or your planning or your programming in your profession. Judges also should engage in evidence-based practices when it comes to making decisions about bond, sentence, and sentencing. And in the criminal justice system, evidence-based practices relate to those corrections practices that have been proven through scientific research to work to reduce offender recidivism. I'm going to harken back to a slide that Judge Anchondo mentioned at the beginning of the presentation. And that was the data about the number of impaired driving episodes per year versus the number of arrests for impaired driving offenses per year. In the United States, each year there are about 1 million arrests for impaired driving offenses. But at the same time, there are about, and again, this is based on very robust research, there are about 120 million incidents of impaired driving each year. That, I am not good at math, but I know it's a lot less than 1% of the people who are out on the road driving impaired are actually arrested and therefore have, whether it's a consequence or an intervention as a result of the impaired driving offense. So it's going on a lot more than those that are involved in the criminal justice system. So we want to make certain that when somebody comes in front of us, we are employing those practices that demonstrate that they assist in reducing future impaired driving and thus can contribute to not only the safety of the driver, but those on the roadway, and particularly those innocent people on the roadway. So for judges, we want to ask them to stop doing things that don't work. We want them to employ evidence-based practices. And unfortunately, oftentimes legislatures, and I'm not picking on the Minnesota legislature because this is true in every state, oftentimes legislatures impose upon judges requirements in impaired driving and in other cases that are not based on research. Just a quick example would be fines. Fines do not demonstrate any effect on recidivism in impaired driving cases. Yet legislatures increasingly are raising fines in impaired driving cases, apparently under the belief that if we fine people more, they'll stop this. And that is not an evidence-based practice. So sometimes, despite what the legislature requires us to do, we are doing things that are not evidence-based. And so our goal is, as judges, is to get information that can help us influence us in making evidence-based decisions. Now, this is probably outside the realm of your daily practice given the audience, but judges should employ something called the risk needs responsivity model of sentencing. And that is, we look at people's criminogenic risk factors. The 8 of them are listed here, and we'll talk about them in just a second. And then we look at their needs, which happen to be the same things. And then their how they learn, so their responsivity, what best works with that individual to help them change their behavior. But we want to focus on these 8 risk and need factors. Their criminal history, so whether it's traffic history or other criminal offenses. Their substance use. Substance use is to me the sort of the shining light of risk factors. It is obviously with impaired drivers such a prevalent concern. Then their pro-criminal attitudes and associates. These 2 factors really relate to your attitudes about crime. Do you have an attitude that engaging in risky behavior, for instance, is okay? It's all right. And do you hang out with people who have the same attitudes? Because we can adopt and normalize pro-criminal thinking if the people around us engage in the same type of thinking as well as behavior, all right? But I want to go to the 3 at the bottom, your family, your marital status, your education and your work, and your leisure and recreational activities. These are 3 risk factors, meaning if you're not in a stable marital or family relationship, that can be a risk factor. But if you are involved in a stable relationship or have supportive family, that can actually help in your rehabilitation. If you're employed or you have an education, again, that can be protective. But if you do not, that can be something that we need to work on to assist in preventing or reducing the risk of future offenses. Leisure and recreational activities are how you spend your free time. And if you have too much free time that you don't have other activities that fill up that time, then that can be a risk for future criminal behavior. So the judge, in employing evidence-based practices, should focus on these 8 factors, their risk factors and the needs to address those risk factors. How do we learn of this? We start with screening and we move towards assessment. We don't have a lot of time today to talk about the specifics here, but I am going to give a shout out to Judge Meyer. She has a tremendous program that she does on screening and assessment. And I encourage you, I apologize, Carrie, but I encourage you to contact her for more information about screening and assessment. Screening is essentially a relatively quick process where we just determine if someone is in need of further intervention. And if they are, we then do a much more comprehensive assessment to determine exactly what that individual's needs are. My needs would be much different than Judge Anchando's, and vice versa. No 2 people are the same. We want to specifically evaluate them based upon their risk and needs. One thing I do want to say about screening and assessment, though, is that impaired drivers often screen low on traditional risk assessments. So it is critical to utilize an assessment that is validated for impaired drivers. But those screening and assessment results are very important to judges because remember, most cases end in a plea, and as a result, the judge knows very little about that individual. And so by gathering additional information through screening and assessment, it can help the judge in their informed decisions about whether to release someone from jail on bond, their sentencing decisions. Are they going to go to jail? Are they going to go to prison? Are they going to be placed on some kind of probation or supervision? And then once they are on that supervision, what are the specific conditions of supervision that are appropriate for that individual to meet their risks and needs? In addition, a screening and assessment influences treatment decisions. As a judge, I should never be telling someone what kind of treatment they should go to, how much treatment, how often. Instead, I should be telling that defendant what their treatment is based upon a validated screening and assessment from a professional who knows what the appropriate treatment is for someone at that risk level. If you appear in front of a judge who says, I make every defendant go to X number of hours of treatment, that is not evidence-based. And it is certainly not based on screening and assessment. We could talk about this for quite a while, this matrix, but what as treatment, as judges, we want to focus on people with high risks and high needs. If we over supervise people with low risk and low needs, we can actually make things worse. Based on a great deal of research, it's very important to only, I heard someone say once, we only want to sprinkle on the right amount to help this individual. We don't want to give them more or less assistance, because if we sprinkle on the wrong amount, we got the wrong recipe, and therefore we are not helping, we may be hurting. But because, as Judge Anchondo said, we often have a lack of resources, we want to focus on those at highest risk and highest needs, because they are the individuals more likely to reoffend. And we still want to help the other people, but there are fewer things that we should be doing. Again, we don't want to make it worse. I'm going to invite Judge Anchondo to respond to this, this quadrant model.
Yeah. Basically, what we do is we start categorizing where we want to place these individuals and what services they're going to be receiving. I usually deal with the high-risk individual. These are the folks that maybe haven't learned from a jail sentence. They haven't learned from probation. So they're going to require what you would see in the left upper hand quadrant as far as services. And it's true what Judge Huffman has indicated. It could be somebody that, you know what, they just had a bad evening and they got arrested. So, you know, we're not going to categorize based on the screening and assessment that they're going to be high risk, high need. Maybe they're going to learn from a diversion program, maybe, you know, minimal supervision, things of that. Maybe they've learned their lesson, they were embarrassed, and we'll never see them again. So this gives us an opportunity to be able to find out what we can do to start changing. First of all, we want to make them aware that they got arrested. Second of all, we want to start changing their environment. And then we want to implement the necessary treatment component that they may need. And that's even if they meet criteria. This is basically identifying those criminogenic needs and the prognostic reads. In other words, what they need. It's like when we all go to a doctor. Judge?
Sure, thank you. So let's look at the profile of impaired drivers, because we've talked a lot about the numbers and risk and needs, et cetera. Who are the people who commit impaired driving offenses? Well, they are predominantly male, 70 to 80% of them. This number would have been much higher about 10 years ago. But women, over the course of about the last 10 years, now make up about 25% of all impaired drivers. So very, very different than it was even 10 years ago. Most of the individuals are between the age of 20 and 30, although the profile is between the ages of 20 and 45. Think about that age and the gender. High risk behavior, right? More risk taking. And as we've seen, risk taking involving speeding, not wearing restraint, distracted driving, and impaired driving all contribute heavily to roadway deaths. I mentioned before that impaired drivers are different and they tend to score low on traditional risk assessments. Part of the reason for that is impaired drivers, generally speaking, not individually, but generally speaking, are employed and educated at higher rates than other criminal offenders. In addition, impaired drivers have a view that they are not criminals. Why? Because their behavior in drinking is legal. So they often do not view their behavior as something that requires a judge to intervene. They don't think they have a problem. And how do you change someone's behavior if they think you're the problem, whether it's the law officer that arrested them, the prosecutor who's prosecuting them, or the judge who's sentencing them? I don't have a problem, you do. Well, that's difficult to change someone's behavior. And the profile of impaired drivers is that remember those risk factors that we talked about: antisocial behaviors, antisocial peers, antisocial personality. That's not a diagnosis, but it's their personality in general. They are more thrill-seeking, impulsive, and have anti-authoritarian attitudes. How do you help shape someone's behavior if, again, they think you got the problem and not them? All right. But as we looked at all those general criminal risk factors, there are additional risk factors that are associated with repeat impaired driving. So we have those general criminogenic risk factors and needs factors that we discussed, but there are additional ones that we must look at for impaired drivers. Obviously, they had a prior impaired driving offense, but the age at the time of their first impaired driving offense is a risk factor for a future one. I'm not going to tell you how old I am, but if I get my first impaired driving arrest today, I'm probably not going to reoffend for a lot of reasons. But if I was 22 years old and got my first impaired driving offense, the likelihood of me reoffending is much more significant. Blood alcohol level. The higher the blood alcohol level, particularly, I believe it's over a 0.15, is a significant risk factor for future reoffending. And then any prior traffic violations, so those speedings, seatbelt, reckless driving, whatever it might be. And then finally, a prior non-compliance with supervision, meaning you had me on probation supervision before, and I have not changed my behavior, or I did not comply with what I was required to in the past. Okay, so just a little bit more information about repeat impaired drivers. Because of typically long-term alcohol dependence, they may have cognitive impairments. So that executive functioning that occurs in the frontal lobe of the brain, where the thinking and the processing goes on, may be impacted. Again, we've already mentioned they often have a higher degree of anti-authoritarian attitudes and antisocial personality. They also, because of long-term alcohol dependence or use or other substance use, they may have had some brain impact in the area of the brain known as the hippocampus that leads to an inability to learn significantly from treatment, meaning that area of the brain can control short-term memory and learning, and then it's affected by long-term alcohol use. And we've already discussed then the mental health concerns with impaired drivers. Okay, so what does the judge need to know about the offender from law enforcement, prosecutors, probation officers, defense attorney? What does the judge want to know? Remember, because most cases end in a plea, I likely know virtually nothing about the defendant or the circumstances of the case. So we want case-specific details. Any information about did you believe that there were drugs involved, but you could only test for alcohol? So was there some indication that there might be polysubstance use, meaning more than one substance impairing the individual? What was their complete traffic history? This is, again, a factor in that system coordination. That do I have all of the information, not just from, for instance, the state of Minnesota, but other states or other jurisdictions, or am I getting a limited amount of information? I need all of the information to employ evidence-based practices. But as Judge Anchondo mentioned earlier, I need to know if this individual has prior impaired driving arrests that either did not result in a conviction or were reduced to some, whether it's a deferral or to another charge. Their substance abuse history. I need to know also, because again, that's a criminogenic risk factor. Their supervision compliance, their family history. If you look at all of these and we go back to that wheel of risks and needs, these are the things that are going to assist me in applying evidence-based practices. These are the criminogenic risks and needs. We also have to remember with impaired drivers, as with all criminal offenders, one size does not fit all. What is good for one person, meaning what meets their risk and need, does not apply to every other offender. Unfortunately, I think all of Judge Anchondo, Judge Meyer, and I all have talked to judges before who take a cookie cutter approach to impaired driving. First offense, this is what you get. Second offense, that's what you get. Third offense, this is what your sentence is. When in fact, a first offender may have a much higher risk than that third offender. We have to look at them as individuals and not as, this is what I do in every case. When we take a cookie cutter approach to sentencing, we are not utilizing evidence-based practices. All right, so what does the judge want to know? First of all, it starts roadside. I want to know everything roadside. And if there's body cam or a cruiser cam, that is really helpful because I can see that person, I can see their behaviors, the depth of the behavior, but the cruiser video or the body cam is not going to provide me with everything. It's not necessarily going to tell me that there were, 8 empty beer bottles in the car, or there was a meth in the car, or a joint that was lit at the time of the arrest. So the law enforcement providing much more detail in their reports, and I fully recognize, as does Judge Anchondo, that this takes more time for the law enforcement officer. But the law enforcement officer has the same goal as the judge, which is we want to get it right because we want to make certain, I'm going to say it differently. We want to help positively influence recidivism. We want to help reduce recidivism. The law enforcement officer can give us more information. That's helpful. We also want any driving behaviors, weaving, being unable to stay in your lane, running over something, hitting a parked object, whatever it might be, but also then their behaviors roadside. What did they say? What did they do? What did they look like, etc. And then those signs of impairment we'd like to have from law enforcement. So there's a great deal of research on what driving behaviors relate to signs of impairment. I'm happy to get you the full list, but I've distilled it down here to categories: maintaining lane position, braking and speeding issues, going too fast, going too slow, braking inappropriately or not appropriately, vigilance problems, so seeing things in the roadway, not seeing them, and then exercising judgment, and then post-stop clues, things like couldn't get their driver's license out of their wallet, couldn't find their wallet, handed you the keys to the car rather than their driver's license, among many other post-stop clues. What do I want from the prosecutor? Judge Anchondo mentioned a circumstance of, here the prosecutor offers this plea. Tell me why, right? Is it a plea because you think it's a bad stop and maybe the evidence will be suppressed? Is it because this is truly a first offender and they're already engaged in treatment and they're taking some steps already to make positive changes? Tell me everything as the prosecutor that you know. But also, when you offer a plea to someone, tell me why this case and why this defendant. Why is this a case you don't want to take to trial? Or why is this a case you want to reduce the charge? Is it because you think you're too busy? Well, that's probably not good enough. I want to know why this defendant, why this case. And then finally, and the overarching concern is public safety served by entering into this plea agreement? Because again, we want to assist in keeping the roadways safer, and it's not necessarily by a plea. But I also want information from the defense. The defense is equally as important as the prosecutor in providing the court with assistance. It might be, hey, judge, the prosecutor has a real problem with something involved in this case, so he's offering me this plea agreement. Again, I want to know that, but I'd also like to know from the defense, tell me things that are positive about your client. Your client's already in treatment. Show me some records that say, you know, your client went the day, this is by way of example, the day after arrest and got an assessment and got involved in treatment and has been going to peer support meetings every day, whatever it might be. The defense's information is equally important in influencing what an appropriate evidence-based practice is. But also from pretrial and probation, and we don't have time to go through this entire list, but all the information they can get me that relates to that wheel of risk and needs, all right? But one of the highlights I want to go over here is transportation, because most often an impaired driver will have some form of a driver's license suspension that's mandatory. We have to work on a plan to get them where they need to go, whether it's work, treatment, to court, to their probation appointments. That is a big factor, that even though it's not a criminogenic factor, but it can be a big factor in their being able to comply with what we ask them to do. All right. You know, should I release this individual? Third DUI, he was a 1.8 high test, but he's married, has children. He's lived and worked in this community 20 years, but he has 2 prior DUIs, and he's currently on probation for his second DUI. He's not presently in treatment, but he's always appeared in court. Should I let him out of jail with no bond? Just based on this information, I would tell you probably not, but I want more. I want a risk assessment. Do we have a plan? Because I don't want to keep somebody in jail just because I can. We want to influence their behavior for their sake and for public safety. When this gentleman is on probation for a second offense and he tests a 1.8, that's more than double the legal limit. I'm going to be extremely cautious about releasing him from jail. Possible conditions for release, things like, one of the things I want to talk with you about is electronic monitoring. For an impaired driver, I want to have an appropriate electronic monitoring device that will tell me if that individual is using substances. We're going to get to that in just a second, but we're going to talk about screening, a brief intervention, and referral for treatment. This practice actually comes out of the medical community and the substance abuse treatment model, where every individual who is arrested for impaired driving should be screened. It's kind of like culling the herd. And by that, I mean, we're going to look at those people who are potentially in need of more intervention, those people that screen very low. We want to get them appropriate assistance, but we don't want to overdo it. But we also want to engage in a brief intervention. And by that, we mean encourage them to attend treatment, because oftentimes I cannot require someone to attend treatment until they've actually been convicted. The evidence is that the earlier after your arrest you go to treatment, the more likely it will be to be beneficial for that individual. And once we've had that brief intervention, we want to give them resources about where they could go to treatment. And again, we want to encourage early intervention, because if the case takes too long, if there's too long between the arrest and the time that the judge tells you to go to treatment, the likelihood of compliance is minimal. And then there are many potential conditions of supervision. DUI courts is what we highly recommend. Judge Anchondo, Judge Meyer, and I all have presided over DUI courts. I will tell you that they work, and the evidence is that they work. Again, we're running out of time, but I want to talk about monitoring devices. There are a variety of them that are available. Oftentimes, the cost of the monitoring device can be a factor. In many jurisdictions, an interlock device on the motor vehicle, similar to what you're seeing in the lower right-hand corner, can be required for drivers. An interlock, though, will only tell you if that person is under the influence of alcohol or has been drinking at the time they get into their car and try to start it up. That's what an interlock will keep you from starting your car. But there are other devices that can monitor alcohol or drug consumption essentially 24 hours a day. So we're really running out of time. I'm going to turn it back over to Judge Meyer.
You're fine. Thank you so much, Judges Anchondo and Huffman. Exactly 11 o'clock, which is where we plan to end and to move into Q&A. So I want to thank you. There was some really timely information in your slides and your presentation. We are definitely seeing the combination of speed and impairment leading to deaths on Minnesota roads. So I appreciate you acknowledging that those are realities, certainly since the pandemic, as well as all the other great information that you both shared. There were several questions that came in while you were presenting. I want to go back to one from an early slide, Judge Anchondo, that wrote about mental health percentages and interaction with the criminal justice system and mental health diagnoses. And our Minnesota expert or contractor who is tasked with trying to get our information consolidated and shared across systems is very interested to know how and where you get information related to mental health data at the court system, at the court level.
I mean, I'm going to answer just a little bit. That data of 45% comes from a number of research studies of impaired drivers. But Judge Anchondo will talk a little bit about we discover that for the individual in their screening and assessment.
Yeah. What I can share, Judge, is the following. I mean, when you see these statistics, and the reason we present it is in your own locality, in your own community, that we have to start looking for those individuals that can help us, the courts, the judges, come and assist us doing these screens and assessments, of course, because we have to stay within our lane. So I certainly will tell you that there are many, many stakeholders, agencies that can help the courts. I'll give you an example. I have many facilities that come to our court and we screen. Probation has screening and assessment. Pre-trial now we've been able to have screening and assessment. Now we've developed that, and it didn't come easy. Okay, I'm going to tell you right now, it didn't come easy. So it takes a while. But I think when you start inviting people to your court or having these meetings, you're going to be able to develop that clinical partnership to be able to now really make a difference in what's going on with these folks. I highly encourage it. I now have the fortune of having an LMSW now in our court. God, you don't know how wonderful that is. I mean, it's like great, but we know other courts don't have that. So it's just a question of reaching out and getting these folks to come into your court or have meetings. And I know that you can develop a great a partnership with these folks, because it's very important as the information has been provided to you.
I want to make one other comment too. Near the end of the presentation, I mentioned that we want information from the defense attorney, right? Whatever they deem is appropriate. It may be about the arrest or the circumstances, but also information about the defendant that could help us. And one thing that a defense attorney can do is send their client for a screening and assessment. If the court does not routinely or automatically do a screening and assessment, that defense attorney can send their client, bring us the results, and that can be very beneficial in deciding a sentence. Yeah. So it can come from the defense too.
Yeah, appreciate those answers. Judge Anchondo, is El Paso still using the CARS assessment? Which
we do.
Yeah, can you explain that a little bit?
Well, you know, many of your assessment tools out there are very helpful. CARS basically can also tell me, because the mental health component comes in. And when we screen now for the mental health, and this is why we put that percentage out there, is because a lot of these drivers do have a mental health issue, and we want to identify it. Once we identify it on the screen and assess, then we populate the screen tool with where we need to send these individuals to start their treatment plan. And that's always very helpful. I thoroughly encourage it, and it's free. and there's training. And I think when everything is free, it's so welcoming. Because I also encourage the IDA, DUI rant, there is a cost, but these screen tools will help you in many ways to start helping these individuals and getting to the root problem.
Thank you. So Kurt, I'd say that I think it's fair to say that individual by individual is how we get the information.
Yeah.
There was a question in the Q&A, which I answered offline, but am interested in your input as well. Is it possible for a judge to get information from the police reports, from the crash scene, on top of what is said in court or what the defense attorney or prosecutor presents to you? Does that make sense?
Yeah, I would say it really depends on the circumstances, and it depends on what the law is in Minnesota. As a judge, I cannot go out and independently obtain information. It would have to be provided to me. And through, again, I'm in Ohio, so through our pre-sentence investigation process, the pre-sentence investigation officer can actually go out and get those things. They can get me the body cam or but the attorneys would know it, and they would know I have it, that it has been provided to me in the sentencing process, and they have then the opportunity to review anything I've seen and comment on it in their allocution in court. So I cannot get it, but through our statutory process, our pre-sentence investigation team can provide me with anything that is available, whether it's going out and getting it, or if from the defense or the prosecution. Judge Elchando, your experience?
Quick response, Judge, and I know this is slow, but I am now encouraging, before I take a sentence, we used to do this in the felonies, we now have these pre-sentence reports, but it's not really a report. But what I encourage the state and defense, those things that we listed as to what we need are the things that I'm now getting. Facts, history, mental health, anything that the defense is doing, bring it to the judge so I can look at it. I set now a docket just specially for that, so I can start getting the information. And this is just briefly, it takes a while to get everybody on board, but I think it's really helpful. We've given you the criteria of what would it be in one of the slides as to what judges need to make a very impactful decision when you're sentencing these individuals.
Yeah, I just want to comment because we want to get it right. We want to get it right for the defendant, but also for the public. And we don't want to do too much. We don't want to do too little. And that's why we use evidence-based practices.
Yeah, I really appreciate that. In my experience, obviously I have an ethical limitation I cannot do my own research. So I find out what they say in court. And if a case goes to trial, I learn a heck of a lot more than I do if someone pleads. So that was,
and as you know, that's often the reason they plead.
That's
because
right.
they don't want you to know the details. But in that pre-sentence investigation process, you can. I mean, do I think I always knew everything? My gosh, no. I don't think I ever knew half of what occurred. But yeah, oftentimes the plea is because I don't want you to know how bad it was.
We want to stop judges real quick. We want to stop that third, fourth, fifth that sometimes escapes and goes through the cracks. We really need to address that, and that's important.
Yep, agree. The other place we hear about it is if there's a victim. So, we're hoping that's property damage, not injury. But if there's someone who knows about the details of the case, we hear about it because the victim has an opportunity to speak at sentencing before we pronounce sentencing. So that's sometimes how we find out details.
And I apologize for neglecting to include that in the presentation. We were not ignoring the victim or the victim's rights, but in our scenarios, we were not making assumptions about injury. And so you make a really important point, and that is the victim's information, but also the victim's perspective are things that we must consider when sentencing any individual, not just an impaired driver.
Appreciate that.
Transparency to the court as well.
There was a question about how you find or whether you find out-of-state DWIs. I put it in the chat for everyone to answer because that's not the judge's lane so much. But maybe in your DWI courts, you were able to know how people find out about priors. Here, it's the prosecutors. They run the driver's license history of that person, not just in Minnesota, but nationwide before they charge, because our charge level is based on how many prior um, alcohol or drug impaired driving offenses there are in the past, or driver's license revocations, and it counts from other states as well. Do you do that in Ohio and Texas?
Yes.
Yes, the problem is not every jurisdiction reports impaired driving offenses in the same way. Not every state shares the same information. And then I'm going to use the tribal communities as an example, and this is not by way of criticism, but the tribal communities often do not share and maybe don't even collect impaired driving information, impaired driving arrests and or convictions. And so it's critical to have a full view of that person's entire driving history, but we can't count on having complete information from out of state, even if you run them through the out of state or databases.
Yeah, Judge, and that's why it's critical to really spread the word that as much information as law enforcement can gather, this helps us when we gather information from all over the country as to their history. Yes, we do have some tribal issues. We're trying to address those as well, so we're getting close.
Yeah, here we have the issue of our nearest neighbor, Wisconsin. Well, for half the state, it's our nearest, where the first impaired driving is not a crime. And so it's difficult to find that information. And then having 11 tribal nations and their own land on the state, we run into exactly the things you talked about. So thank you for sharing that. So I appreciated what you were saying in your presentations about determining what it is that's impairing, what the substance is that's impairing, and not doing stop testing. I think that's critical in Minnesota because of the way the marijuana impaired driving law was written. So I appreciate that you covered that, Judge Anchando. I don't know if you have any more to say about sort of the stop testing theory and why it's important to know all the substances on board.
Well, if we're going to be getting to the root issue of these individuals, we're slowly learning even from our clinicians and pharmacology people that the more information we get about these individuals when they're arrested, it is then more important as to what they're suffering from. So we know that the statistics is it's just not alcohol. It's polysubstance, it's co-occurring. It could be even prescription overdose on their part. It's very, very important that even at roadside and in law enforcement, that we do not stop just at the alcohol. We truly need to know what is going on with this individual. We deal with a very complex individual called the impaired driver. And we're slowly learning that the more we gather, the more information, even regarding their mental health status, because again, we're judges, we're not doctors, we're not psychologists. We need this information because we're going to need those treatment providers to help us make these individuals better, especially when I'm supervising and I'm having supervising hearings to make sure that they're engaging in what they need to correct their behavior. So yes, stop, test, limitations need to stop. We need to go further. We need to spread the word that we need to go beyond that so we can understand what's going on with these individuals. And I think it's incumbent upon us to do that.
Well, and I think another challenge too is not just the stop testing, because stop testing is often borne by resources. You know, your BAC level, let's say, was a 1.0. Okay, that's sufficient for an impaired driving offense. There's a perceived lack of need to move on to any additional testing. But that's kind of where the problem starts. It's also not every lab, there are no, while there are standards for how the substance is tested, there are no standards for across the country for cutoff levels. So one lab may have a positive test for cannabis at X number of nanograms, where another lab has a higher or lower level for a positive. So, you know, those challenges. And the thing that I will say is that I think as a system, we are making great progress in other opportunities to engage in testing. You have your very robust electronic search warrant program in Minnesota, but we're making a lot of progress in oral fluids. Your neighbor, Wisconsin, just graduated their first class of law enforcement phlebotomists in October. So there's a lot of things going on, but they're not employed systemically yet.
But the
We're a
word,
ways off from
and-
that.
but the word is getting out, so I think we're making progress. Yes.
Great. I
Wow.
want to thank both of you again so much for coming to Minnesota via Reno, Nevada, via Ohio and Texas. We really appreciate your time today and sharing your expertise. Participants who are still here, please note that the QR code for the evaluation survey is on your screen. I believe you may also get an email later with the connection to the survey code and to the website, where the PowerPoint will be posted in a few days. I think that I got all the answers, your questions answered. We really appreciate your time. I want to specifically call out Linda Dolan and Jackson Piper from the University of Minnesota for making the Hotdish happen. So we appreciate your time, and we will and the comments. I hope you're reading these, judges, the comments that are coming through on the chat. Thank you so much. Have a great day.